The Supreme Court on Monday referred a batch of pleas challenging the abrogation of 317 Jammu and Kashmir to its constitution bench. A 5-judge constitution bench will commence hearing on the petitions today. While the blackout lobby continues to fear monger, the Modi Sarkar is confident of winning the legal battle in the top court. Petitions of National Conference MPs Akbar Lone, Hasnain Masoodi, Jammu Kashmir People's Conference Chief Sajjad Lone, Shela Rashid and Shah Faisal will be heard by the Apex Court today. And our editor-in-chief Rahul Shankar spoke to eminent lawyer Harish Salve on this issue. Listen.
Whether you believe that the government has acted illegally, as the contention is.
I don't accept that position. My reading of the Constitution suggests that what the government has done is within the provisions of the Constitution. You must understand that while framing the Constitution, sub-article 3 of Article 370 made a provision saying the President can, by notification, disapply the Constitution or apply it with such changes or modifications as may be. If the Constitution is to be amended, for example, if a provision as significant as Article 35A had to be embedded in the Constitution, it would require Parliament 2/3 present and voting, Article 368, and it would be subject to the basic structure challenge. But Article 370 allows the President by notification to make adaptations to the Constitution, and including disapply the Constitution, disapply Article 370 completely. 370 sub-article 1 also allows the President to apply such parts of the Constitution with such changes, etc., which establishes that this was a special provision made to deal with Jammu and Kashmir. I don't want to join the political battle on whether this was temporary, permanent, semi-permanent, but as a constitutional lawyer, a provision which allows the President to modify the Constitution in its application to a significant part of India, i.e. a whole state of India, should be construed as being a temporary provision. And that's what its long title says. Now, whether politically over a period of time this became temporary or permanent is quite another matter, and I don't want to enter that debate.
Has the spirit of legislative consent been violated? There is no legislative assembly in function, sir.
So let me address the two issues distinctly. I don't know whether 370 has been abrogated or the Constitution, which had been abrogated in Kashmir, has been brought back into force. You can look at it either way.
That's a clever way of...
A lot of beneficial... It's not a clever way, it's a perspective.
Yeah.
If you start with a presumption that this was always how it was meant to be, and what has been done is morally wrong or politically wrong, then you start using adjectives like this has been abrogated, this has been emasculated, etc. I can equally argue the whole Constitution had been emasculated by 35A. 19(1)(c), the right to settle in any part of India, is basic to a federation. You took that away for Kashmir for forever. Why? So one can argue this, the wisdom of doing all this equally strongly from both sides. And there were problems in Article 35A. There is a judgment of the Supreme Court which recognized that there were those who by the same token should have been entitled to reside but were not residents, and they have been denied their right to reside in that state. So this sort of using of adjectives obscures the legal issues, and I'm not addressing the political issues. Personally, I'm for this, but I'm not addressing the political issues. I'm not a political expert. The legal aspects are, these are machinery provisions. These are machinery provisions which have imparted flexibility in otherwise a constitution which is robust and applicable fully. The flexibility itself is for political decisions to be applied in a state. That's why it says the President by order. It doesn't require the Parliament to do anything. President by order means the executive government of the Union of India. The executive government of the Union of India decides which part of the Constitution applies or doesn't apply in Jammu and Kashmir. That was the extent of flexibility. If the government of India today says, let's apply the whole constitution, how can it be legally wrong? You may say, no, by a flux of time, people had been assured and you should not have done it. The should or should not is not an argument, which the court will go into, which I want to address. But this convoluted and this, etc., is all wrong. Now we come to the second issue, the assembly of the state. This has two dimensions. The assembly of the state stands dissolved, and it stands dissolved for good reason. There is no stable assembly of the state. Today, Parliament is exercising the powers of the state assembly. Parliament, by a 2/3 majority, has passed this law, has passed this resolution. Parliament could have amended 368 by using powers of 368 and knocked 371 out of the Constitution completely. 2/3 present and voting have ratified these resolutions. So I don't see where this whole argument of bypassing a state assembly or getting past it applies. Parliament has been passing the budgets for the state. This is ultimately an important political decision. It has been applied in a manner which the Constitution permits. And I think it will be a grave blunder to superimpose the political arguments over the legal structure.